Okay, I'm showing 9 o'clock. Is everybody ready to start?
Ready here.
Ready, Chairman.
All right.
Morning,
Thanks so
everyone.
much. Good morning, everyone. This meeting is called to order. Mr. Troman, has anyone signed up for public comment?
Morning, Commissioners. No, we do not have anyone sign up for public comment this morning.
Thank you very much. Good morning, Ms. Miller.
Good morning.
I'm showing that we have no cases to reconsider under agenda item 3. Is that correct?
Yes, that is correct.
All right, let's move to tax liability cases under agenda item 4. I believe we have one tax case on docket 26.
Yes, sir, that's correct. That is correct. It's case number TD-20-059-0320. Commissioner Demerson?
I agree with staff recommendation.
Commissioner Alvarez?
I agree with staff's recommendation.
And Mr. Chairman?
Agree with staff recommendation.
Thank you.
Agenda item 5. We have no fair housing cases under agenda item 5, correct?
That is correct, sir.
Let's move to agenda item 6. We have no wage claim cases pulled for additional discussion on docket 26.
That's correct. You should have received the short form dissent list.
I move we accept staff recommendations on the remaining wage claim cases on docket 26.
I second the motion except for those cases on which I am dissenting as reflected on the wage claim short form dissent list for docket 26.
I concur with the chairman's motion, except for the cases on which I'm dissenting as reflected in the wage claim short form dissent list for docket 26.
The motion passes with the exceptions noted.
Thank you, sir.
That brings us to agenda item 7 and consideration of unemployment insurance cases on docket 26. Please proceed when you're ready.
Thank you. The first case is case number 2465859. Commissioner Demerson?
The AT decision should be affirmed because the claimant did not establish good cause to quit. The claimant states that she resigned because her manager falsely accused her of dishonesty. However, the record shows that the employer investigated and addressed the issue by coaching the manager, and there were no further incidents. Although the claimant felt entitled to know the details of the action taken against her manager, the employer was not required to furnish that information, and refusing to do so was not unreasonable. Moreover, the claimant's decision to escalate her concerns does not mean that the initial allegations were sufficiently egregious to induce someone to quit. Ultimately, it appears that the claimant was upset that the employer did not follow her exact wishes for resolution of her complaint. Most importantly, the final incident occurred in early May, and the claimant did not resign until late July. This suggests that the working conditions were not intolerable since the claimant continued working for almost 3 more months before she quit. In addition, the claimant stated that she only worked until July so that her retirement account could become vested, and she turned in her notice the day after that occurred. Thus, the evidence shows that the claimant quit for personal reasons, and we should affirm the AT decision, voluntary leaving, no chargeback.
The decision should be reversed. The employer's testimony lacked credibility as it was shown that the employer was dishonest when claiming that the claimant did not provide a reason for quitting and when claiming that the claimant did not try to resolve her workplace issues. As such, the claimant's testimony carries greater weight. While in front of coworkers, the claimant's manager accused the claimant of a pattern of lying. The employer did not deny this occurred and provided no evidence that this was an appropriate action by a manager. The claimant complained to HR and tried to resolve the issue with the employer, but the employer made it clear that they were not going to address the claimant's concerns. Therefore, the claimant had good cause to quit. Reverse the AT, no voluntary leaving chargebacks.
Affirm the AT, voluntary leaving, no chargeback.
Short form dissent.
Thank you. I have a short form dissent for Commissioner Alvarez. Case number 2469426. Commissioner Alvarez?
The decision should be reversed. The claimant provided sworn testimony and documentation supporting a finding that she worked and earned more than 6 times her weekly benefit amount. The initial claim should be deemed valid. In the alternative, the documentation from the claimant provides a contact number for the employer. If my fellow commissioners continue to doubt the evidence, we should rehear the case and contact the employer for testimony and evidence.
I'm going to be in agreement with rehearing, but let me read this into the record. The record lacks sufficient evidence to reach a conclusion that the claimant earned any particular amount of wages from anyone. claimant should be given a chance to offer whatever newsletter she stated that she has showing an address for the alleged employer. In addition, she should be instructed to submit a copy of her income tax report for the relevant time period showing that she's reported her alleged earnings to the IRS and paid whatever income tax may have been due on such earnings. Finally, we need to send a memo to the tax department to investigate whatever company the claimant indicated that she worked for and determine, if possible, what amount of wages the company paid her and should have reported to TWC as taxable wages. Once all of that information is in the record, we will have a better basis for determining whether the claimant earned sufficient wages for a new claim. Accordingly, we should hold a rehearing to take all relevant testimony and evidence from the claimant, including any reports she made to the IRS concerning her earnings, and to take into record the results of a tax department investigation into the alleged employer and the wages that it paid to the claimant for her services.
Rehear.
Thank you. We have a majority vote to rehear the case. Next case is case number 2476490. Commissioner Alvarez?
The decision should be modified. The claimant and her spouse were living in San Antonio. The claimant's spouse was offered a job in Phoenix, Arizona. The claimant quit to move with her spouse to Phoenix, Arizona. The employer did not have any local jobs in Phoenix for her. The claimant considered childcare issues when making the decisions to move, but this should not change the nature of the separation. Shared child care responsibilities are expected in the 21st century of marriage. The claimant quit to move with her spouse, and she should be qualified for no more than 6 weeks. Modify the AT, quit to move with spouse, 6 weeks disqualification, no chargeback.
The AT decision should be affirmed. The claimant testified that she quit due to child care issues. While that is good, a good personal reason for resigning, there's no exception to disqualification that applies to the facts of this case. As such, we should affirm the AT decision, voluntary leaving, no chargeback.
Affirm the AT, voluntary leaving, no chargeback.
Short form dissent.
Thank you. I have a short form dissent for Commissioner Alvarez. The next case is case number 2482632. Commissioner Demerson?
The AT decision on good cause should be reversed. The employer planned on participating in the hearing on his day off from work. However, he could not call in for the hearing due to an unexpected lack of cell phone reception, which was a circumstance beyond his power to control. While true that the employer was in a remote location of his choosing at the time of the hearing, good cause has been granted to claimants under similar circumstances in the past. The employer, in this case, should be afforded the same courtesy for the purposes of consistency and equity. The employer established good cause for its non-appearance, and the case should be resubmitted for merits testimony.
I would affirm the employer failed to make proper arrangements to participate in the hearing, which was a circumstance within the employer's control. Therefore, the employer did not establish good cause for their non-appearance. Regarding the job separation, the claimant denied the employer's allegations in his pre-hearing statements, and the employer only provided secondhand evidence. As such, the AT decision should be affirmed. The employer did not have good cause, no misconduct, chargeback.
Reverse the AT, employer established good cause for AT1, resubmit.
Thank you. We will resubmit the case. Case number 2485713. Commissioner Alvarez?
The AT decision should be affirmed. The claimant denied that he shoved a resident or used any profanity. The parties enter the hearing with equal credibility. Both the AT and the initial claims examiner found the claimant's denials of wrongdoing to be credible. The AT is in the best position to judge the credibility of the parties. The employer's evidence is insufficient to prove misconduct. Affirm the AT, no misconduct, chargeback.
The AT decision should be reversed because the claimant self-disqualified. The claimant admitted in his initial statements that he was on final warning for being rude and unprofessional to a resident. During the final incident, the claimant was again rude and unprofessional. The employer's firsthand testimony, coupled with the resident's statement in Exhibit 2, establishes that the claimant shoved the resident at least once during the final incident. This evidence outweighs the claimant's denial. In addition, the claimant admitted in his own testimony that when speaking to the resident, he told her I'm glad you're my mother and I'm not your son. I'm glad you're not my mother and I'm not your son. This comment alone was unnecessary, inappropriate, rude, and against company policy. Based on this evidence, the record overwhelmingly supports a finding that the claimant mismanaged his position of employment. We should therefore reverse the AT decision, misconduct, no chargeback, adequate employer response.
Reverse the AT, misconduct, no chargeback, adequate employer response.
Short form dissent.
Thank you. I have a short form dissent for Commissioner Alvarez. Case number 2491406. Commissioner Alvarez?
The decision should be reversed. The claimant was unable to appear for their first hearing because he was attending to a medical issue. The hearing was scheduled for 10:15 a.m. and the claimant was in the doctor's office from 9:30 a.m. to 10:45 a.m. Since the claimant was in the doctor's appointment at the time of the hearing, he has good cause for his non-appearance. Reverse the AT, good cause for claimant's non-appearance, and resubmit.
The AT decision should be modified. On good cause, the claimant testified that he was in a medical appointment and forgot about the hearing. The record further shows that the appointment was elective. Based on this evidence, the claimant did not establish that his failure to appear at the hearing was due to circumstances beyond control. He did not establish good cause for his non-appearance. Regarding the job separation, the record shows that the claimant was not working to the best of his ability as he was previously capable of meeting the employer's expectations. The claimant's failure to comply with the employer's reasonable request after prior warnings constituted work-connected misconduct. We should modify the AT decision. The claimant did not have good cause for his non-appearance, misconduct, no chargeback, sever adequate response.
And Mr. Chairman? Mr. Chairman?
I believe it's green. There he is, right there.
Okay. Here we are.
All right.
Ms. Miller,
Yes, sir.
read the case number 2. I just want to make sure I'm on the right one here.
Certainly. It's 2491406.
My vote is reverse the AT, claimant established good cause for AT1, resubmit.
Thank you. We will resubmit the case. Next case is case number 2492034. Commissioner Demerson?
We should resubmit this case on a later date after a memo from the General Counsel's office. There was a dispute between the parties as to whether the claimant committed a policy violation by disclosing HIPAA-protected information about a patient. The claimant admits in testimony that she basically told the charge nurse that the man down the hall and around the corner was having pain. This is an admission that the claimant revealed the patient's gender. Accordingly, we should hold this case pending a memo from the General Counsel's office as to whether gender constitutes individually identifiable health information protected under the HIPAA law, and whether any exceptions would apply to a disclosure of such information.
The decision should be reversed. The employer only provided testimony from an HR specialist who had no firsthand knowledge. Therefore, the claimant's testimony carries greater weight. The claimant was discharged for allegedly violating HIPAA regulations when she told a charge nurse that a patient needed pain medication in the presence of another person. However, the claimant did not disclose the patient's name or other identifying information. The claimant only said the patient was down the hall and around the corner. This was enough information for the charge nurse to know who the claimant was referring to without violating HIPAA. As the greater weight of the evidence supports a finding that the claimant did not violate HIPAA, the claimant should be qualified for benefits. Reverse the AT, no misconduct, bill reimbursing employer.
Can you read me Commissioner Demerson's vote again, please?
Yes, sir. He voted to resubmit the case after receiving an OGC memo regarding whether The information provided by the claimant was a HIPAA violation, specifically whether revealing the gender of the patient was enough individual identifying information to violate HIPAA.
Okay, I will concur with Commissioner Demerson.
Okay, we will request a memo from OGC and resubmit the case after it's received. Next case is case number 2496354. Commissioner Alvarez?
The decision should be reversed. The employer provided only hearsay testimony, and much of his testimony was vague. The only allegation with real detail was the claimant stating that she was working on her resume. The claimant testified that she was joking and that her employer did not provide any testimony or evidence to contradict the claimant's sworn testimony. The evidence is insufficient to establish misconduct connected with the work. Reverse the AT, no misconduct, chargeback, void adequate response ruling.
The AT decision should be modified. The employer received a complaint that the claimant mishandled a billing issue with the patient. The claimant did not deny mistreating the patient, and this was not the claimant's first incident of poor customer service. In fact, the claimant acknowledged that she had prior discussions with the employer concerning her conduct and poor communication with others. Thus, the claimant was on notice that her conduct was unacceptable and she should have known her job was in jeopardy. As such, the claimant's failure to correct her behavior constituted mismanagement of her position of employment, and we should modify the AT decision. Misconduct, no chargeback, sever adequate response.
Reverse the AT, no misconduct, chargeback, void adequate response.
Short form dissent.
Thank you. I have a short form dissent for Commissioner Demerson. The next case is case number 2496593. Commissioner Demerson?
The appeal tribunal decision should be affirmed. The claimant acknowledged that she was aware she could use the company vehicle for personal use. In addition, the claimant also stated that she had been told to not use the company vehicle to attend her daughter's extracurricular activities. Nonetheless, the claimant continued to use the company vehicle for personal use of dropping off and picking up her kids at school. The claimant also stated that when she was discharged, the employer's manager expressed that the way the claimant was using the vehicle was a liability. As such, the claimant's actions constituted work-connected misconduct. We should affirm the AT decision. Misconduct, no chargeback.
The decision should be reversed. Employees were told not to take their company vehicles to dinner, bars, or places where they would be stopped for long periods of time. The claimant was specifically told not to take the vehicle to her daughter's extracurricular games. After this instruction, the claimant stopped using the vehicle to go to her daughter's games. She continued to use the vehicle to drop her children off and pick them up from school. However, this was not a violation of the employer's policy. The claimant was not at the school for a long period. The school was on her way to work and it was outside of business hours. Therefore, as the claimant complied with the employer's policy, the employer has not shown misconduct. Reverse the AT, no misconduct, chargeback.
Reverse the AT, no misconduct, chargeback.
Short form dissent. Sherry.
Thank you, sir. I have a short form dissent for Commissioner Demerson. Case number 2496629. Commissioner Demerson?
The appeal tribunal decision should be affirmed. The claimant received a progress report and was told that she must sign it. Despite having multiple opportunities to do so, the claimant refused to sign the report each time. Considering that the claimant was suspended for failing to sign the document and that she was told that she must sign the document, it is supportable to conclude that a reasonable person in the claimant's position knew or would have known that failing to sign the report would lead to discharge. As such, the claimant's failure to sign the report after multiple opportunities to do so was a clear demonstration of not following instructions and constituted misconduct connected with the work. We should therefore affirm the AT decision, misconduct, reimbursing employer, not billed.
The decision should be reversed. The claimant was asked to sign a document agreeing to a substantial change to her hiring duties. Not only were these duties outside the original scope of her job, the added duties were too numerous for the claimant to complete. She tried at her best to complete the task, but refused to sign a document agreeing to change in duties. The claimant should not be disqualified for refusing to agree to a substantial change to her hiring agreement. Reverse the AT, no misconduct, bill reimbursing employer.
Reverse the AT, no misconduct, bill reimbursing employer.
Short form dissent, Sherry.
Thank you. I have a short form dissent for Commissioner Demerson. Next case is case number 2497279. Commissioner Demerson?
The appeal tribunal decision should be modified. The claimant admitted that he filed a fraud claim with the employer knowing it was false. The claimant contends that his action was not work-related since it was his personal account, but the claimant's contention is not persuasive because he made his actions work-related the moment he submitted a fraudulent claim with the very entity that he worked for. At that point, the claimant made his personal affairs the business of the employer. Since the claimant acted in an unethical manner and in a way that was clearly against the employer's best interest, his actions constituted misconduct connected with the work. We should therefore modify the AT decision, misconduct, no chargeback, sever, adequate response.
The decision should be reversed. The issues that the claimant had with the bank account were personal and not related to the work. The evidence does not establish work-connected misconduct. Reverse the AT, no misconduct, chargeback, void, adequate response.
Modify the AT, misconduct, no chargeback, sever, adequate response.
Short form dissent.
Thank you. I have a short form dissent for Commissioner Alvarez. Case number 2499073. Commissioner Alvarez?
The decision should be reversed. The claimant received a lump sum of payment on February 27, 2020, in accordance with the employer's change of control severance plan. This plan had been in existence since at least January 1st of 2011, well before the claimant's separation. The claimant's severance was paid in accordance with the written contract negotiated with the employer before the date of separation, and thus this non-disqualifying and thus is non-disqualifying under section 207.049B2 of the Act. Reverse the AT, no disqualification due to severance.
The AT decision should be affirmed. The claimant received over $360,000 in severance pay. According to the claimant's initial statements, that amount covered 2 years' worth of the claimant's salary. Based on an alleged violation of the Civil Rights Act of 1991, nor was it pursuant to a claim or cause of action filed in connection with the employment relationship. There's also no evidence that the payment was negotiated, as the evidence makes clear that the amount was based upon a predetermined formula. Therefore, none of the exceptions to disqualification under section 207.049B of the Act are applicable to this case. Since the claimant received payment around February 27, 2020, the starting date of disqualification is appropriate. We should affirm the AT decision. The claimant received disqualifying severance pay from February 23rd, 2020 through January 30th, 2021.
Reverse the AT, no severance, disqualification.
Form.
I have a short form dissent for Commissioner Demerson.
Thank you.
Case number 2500916. Commissioner Alvarez?
The decision should be modified. The claimant has mental health issues. The claimant provided a letter from her doctor explaining that her impulsive decision to quit was a symptom of her medical condition. Because the claimant quit due to her medical verified illness, the claimant should not be disqualified. Reverse the AT, no voluntary leaving, no chargeback, MBI. In the alternative, the case should be reheard to consider all of the medical evidence that the claimant has provided.
The tribunal decision should be affirmed. The claimant cited medical issues as the reason why she resigned from her job. However, the claimant submitted medical documentation establishing that she was cleared to return to work. As such, she quit without good cause connected with the work. We should therefore affirm the AT decision, voluntary leaving, no chargeback.
Affirm the AT, voluntary leaving, no chargeback.
Short form dissent.
Thank you. I have a short form dissent for Commissioner Alvarez. Case number 2500961. Commissioner Demerson?
We should grant a rehearing in this case. Despite having continued this case for the submission of documents, the record was not adequately developed. We have no specifics about the final incident that led to the claimant's quitting, nor do we have testimony from the employer addressing any knowledge of the claimant's dissatisfaction or any steps the employer may have taken to address her concerns. In the absence of much needed relevant information, we should rehear this case before rendering our decision.
The AT decision is supportable. The claimant quit the job because of intolerable working conditions. Specifically, she had to manage staff who were insubordinate. She was threatened by staff, and staff were drinking on the job when they were supposed to be working. She brought her complaints to the employer, but they were not addressed. She therefore had good cause connected with the work to quit. Affirm the AT, no volunteering, leaving, chargeback.
I would agree to rehear.
Thank you. We will rehear the case. Case number 2500969. Commissioner Demerson?
We should reverse the appeal tribunal decision. The facts are not in dispute. When the claimant notified the employer that she could not perform her duties as a delivery driver due to car issues, the employer reassigned the claimant to a different position and advised her to come to work. The claimant flatly refused and used obscenities in her response to the shift manager. Because the claimant's actions were blatantly insubordinate, she mismanaged her position of employment. Accordingly, we should reverse the AT decision, misconduct, no chargeback, adequate employer response.
The AT decision in this case is supportable. The claimant was discharged because she was not absent from work for 1 day due to her vehicle's malfunction. There was no evidence that the claimant had been warned about excessive absenteeism, and she provided adequate notice of her absence. Her actions did not rise to the level of misconduct connected with the work. Affirm the AT, no misconduct, chargeback.
Reverse the AT, misconduct, no chargeback, adequate employer response.
Short form dissent.
Thank you. I have a short form dissent for Commissioner Alvarez. The next case is case number 2503587. Commissioner Demerson?
The appeal tribunal decision is fully supportable and should be affirmed. The claimant was discharged after being insubordinate with the service manager. In addition to the service manager's testimony, the employer presented a written statement from the dispatcher who also witnessed the claimant's behavior. In light of the claimant's weak and unconvincing denial, and considering that the claimant had been counseled after similar behavior in the past, the employer met its burden and established that the claimant mismanaged her position of employment. We should affirm the AT decision, misconduct, no chargeback.
The AT decision is not supportable. The claimant was discharged after she supposedly made inappropriate remarks to a service manager in a disagreement. The service manager in question admitted in his testimony that he may have used the same kind of language that the claimant used, and he did not specify in his testimony what exactly the claimant said that was considered inappropriate. The employer did not provide any firsthand testimony of the claimant's conduct on the final incident. The employer did not provide sufficient evidence to meet its burden to establish that the claimant was discharged for misconduct connected with the work. Reverse the AT, no misconduct, chargeback.
Reverse the AT, no misconduct, chargeback.
A short form dissent.
Thank you. I have a short form dissent for Commissioner Demerson. Next case is case number 2504102. Commissioner Demerson?
We should reverse the appeal tribunal decision. Witness testimony and a recorded telephone call are more than sufficient to prove that the claimant authorized the substantial discount card without employer approval. While the employer learned of the claimant's actions in January, the employer did not unduly delay the claimant's discharge. The employer initiated an investigation, which included reaching out to the parties involved. On February 24th, the fundraising company involved in the final incident informed the employer that it had a recording of its call with the claimant regarding the transaction. The company submitted the recording to the employer, who discharged the claimant 3 days later. Because the preponderance of the evidence established that the claimant engaged in the actions alleged, and the employer discharged the claimant only 3 days after receiving conclusive and irrefutable proof, the employer has met its burden of proving misconduct connected with the work. We should reverse the AT decision, misconduct, no chargeback, adequate employer response.
The AT decision is affirmed. The claimant was discharged after she was accused of issuing a discount card without authorization. The claimant denied issuing the discount card in question. Additionally, the employer unreasonably delayed acting on her accusation when they waited over a month after learning of the issue before they discharged the claimant. The employer has failed to establish that the claimant was discharged for misconduct connected with the work. Affirm the AT, no misconduct, chargeback.
Reverse the AT, misconduct, no chargeback, adequate employer response.
Short form dissent.
Thank you. I have a short form dissent for Commissioner Alvarez. The next case is case number 2504207. Commissioner Alvarez?
The decision should be reversed. The claimant's wife moved to California to look after her parents. The claimant quit his job in Texas to move with her. As the claimant quit to move with his spouse, he should only be disqualified for 6 weeks under Section 207.045C. Reverse the AT, spousal leaving, 6 weeks disqualification.
The appeal tribunal decision should be affirmed. The claimant had a good personal reason for leaving his job, but it was not connected with the work. We should therefore affirm the AT voluntary leaving.
Modify the AT, quit to move with spouse, 6-week disqualification.
Short form dissent.
Thank you. I have a short form dissent for Commissioner Demerson. Case number 2507372. Commissioner Alvarez?
The decision should be reversed. The claimant last worked on February 14, 2020 because he became ill. The claimant made several attempts to contact the employer regarding his illness. The employer has not provided any specific reporting policy they allege the claimant violated. Instead, the employer testified that the claimant was released because they have an unwritten rule to separate employees who do not work for 16 straight days. The employer closed the claimant's file on March 2nd, 2020. The claimant was not healthy enough to work again until March 6th of 2020. Reverse the AT, no misconduct, no chargeback, MBI.
The appeal tribunal decision should be affirmed. The claimant quit his job due to medical issues. However, he did not reach out to the employer after he recovered from illness. Per commission president, this constituted a voluntary quit without a good cause connected with the work. We should therefore affirm the AT decision, voluntary leaving, no chargeback.
Affirm the AT, voluntary leaving, no chargeback.
Short form dissent.
Thank you. I have a short form dissent for Commissioner Alvarez. Moving on to case number 20. Case number 2508112. Commissioner Demerson?
We should reverse the appeal tribunal decision. It was reasonable for the employer to request that the claimant pay for damages to the company vehicle, which occurred while in the claimant's possession. Rather than discuss any concerns the claimant had with the employer's request, the claimant quit effective immediately. Because the claimant's working conditions were not intolerable, the employer's request was not unreasonable, and the claimant quit without providing the employer an opportunity to remedy any concerns he may have had. The claimant's quitting was without good cause connected with the work. Accordingly, we should reverse the AT decision, voluntary leaving, no charge back, adequate employer response.
The AT decision should be affirmed. The claimant quit his job when he was told by the employer that he would be responsible for paying for damage to the employer's vehicle that occurred as a result of a third party's attempt to steal the vehicle. The employer neglected to repair the theft deterrent system in the vehicle, which caused the attempted theft. Under the employer's policy, the claimant is only responsible for paying for damages or damage caused by his negligence. The employer's attempt to force the claimant to pay for damage to a company vehicle for which the claimant was not liable gave the claimant good cause connected with the work to resign. Affirm the AT, no voluntary leaving, chargeback.
Reverse the AT, voluntary leaving.
Mr. Chairman, are you there? Hello, Mr. Chairman?
Can you hear me?
I can hear you now. I did not hear your vote, though.
Okay, this is case number 2508112.
Yes, sir.
My vote was reverse the AT, voluntary leaving, no chargeback, adequate employer response.
Thank you.
Short form dissent, Ms. Miller.
Thank you. And I have a short form dissent for Commissioner Alvarez. Case number 2509831. Commissioner Demerson?
We should modify the appeal tribunal decision. I agree that the employer initiated the job separation. The day after the claimant submitted her resignation, she engaged in an inappropriate, unprofessional, and very public outburst during which she yelled, screamed, directed obscenities at the employer's directors. The employer sent the claimant home after the incident and discharged her the next day. The employer meant to have the claimant work for more than 2 weeks after she submitted her resignation, but the claimant's intervening unacceptable behavior resulted in acceleration of her discharge. Because a reasonable employee should have known that such behavior would result in termination, the claimant mismanaged her position of employment and was discharged for misconduct connected with the work. We should modify the AT decision. Misconduct, no chargeback, adequate employer response, sever the wages in lieu of notice issue.
The AT decision on the separation should be affirmed. The claimant gave a notice of resignation on 3/4/20 with an effective date 2 months in advance. The employer informed her that her policy did not allow for such a long notice period and required her to make her resignation effective 3/25/20. She was not allowed to rescind her resignation and was paid through that date. The claimant gave notice of resignation of more than 2 weeks, which the employer accepted early. Pursuant to long-standing commission policy, such early acceptance of a claimant's notice of resignation constitutes an involuntary separation. Since the employer accepted her resignation early pursuant to its general policies and not due to any misconduct by the claimant should not be disqualified. Modify the AT, no misconduct, chargeback, severance pay disqualifications.
Modify the AT, no misconduct, chargeback, sever wages in lieu issue.
Short form dissent.
Thank you. I have a short form dissent for Commissioner Demerson. And the last pulled case is case number 2510754. Commissioner Alvarez.
The decision should be reversed. Under Section 201.01121 of the Act, temporary employers send employees on assignments during employee absences, temporary skill shortages, seasonal workloads, special assignments, and projects or other similar work situations. The claimant in this case had been on assignment far well over a year. Given that this assignment was not temporary in nature, Section 207.045H of the Act should not be applied. The claimant stopped working because he was laid off. There has been no allegation of misconduct. Reverse the AT, no misconduct, chargeback.
The appeal tribunal decision should be affirmed. The claimant signed the employer's reporting policy that unemployment benefits could be affected if he did not comply with the reporting procedure. The claimant stated that he did not contact anyone after his contract was over. As such, the claimant's failure to follow the employer's reporting policy constituted a voluntary quit without work-connected good cause. We should therefore affirm the AT decision, voluntary leaving, no chargeback.
Reverse the AT, no misconduct, chargeback.
Short form dissent.
Thank you. I have a short form dissent for Commissioner Demerson. And that was the last UI case pulled for additional discussion on docket 26. You should have received the short form dissent list previously.
I move we accept staff recommendations on the remaining UI cases on docket 26.
I second the motion except for those cases on which I'm dissenting, as reflected on the UI short form dissent list for docket 26.
I concur with the chairman's motion except for the case on which I'm dissenting as reflected in the UI short form dissent list for docket 26.
Motion passes with the exceptions that are noted.
Thank you, sir.
Thank you.
Thank you,
All right,
Sharon.
we need to take just a quick break so I can address a technical issue here. And so give me about 2 minutes and we'll resume the rest of the meeting.
Sounds good.
Thank you, sir.
Okay. Hopefully that fixed. Is everybody ready?
Yes, Chairman.
Yes, sir.
Ready here.
Great. We're back in session. This is a session consideration possible to adopt program year 2020 and fiscal year 2021 allocations, planning estimates, and funding distributions for adult education and literacy programs.
Good morning, Chair and Commissioners. Mr. Cerna, for the record, Chris Nelson, Chief Financial Officer. Can you hear me?
Yes.
Okay. This morning you have before you the FY21 PY20 education and literacy allocations. As you recall, on May 12th, the Commission was presented with AEL planning estimates for contracts that would go into effect July 1st, based off planning numbers provided by the Department of Education. TWC expects to receive the final state allotment on July 1st. However, we have reached out to the Department of Education last week and were notified that they do not expect the final allotment to change at this point. There are two changes made to the final allocation being presented this morning versus the planning estimate document. First, the total AEL allocation, excluding EL Civics, consists of approximately 77% federal funds, 14% state, and 9% TANF funding. Starting last year, TWC began validating with its available data the AEL program services that AEL program serves enough TANF eligible clients to fully support spending the TANF funding. Since local providers are no longer required to document TANF eligibility, the allocation by funding source has been recalculated so that each area and provider receives the same equitable distribution of each funding source and the associated administrative limit with each funding source, keeping their total allocation the same as the planning estimate numbers. The second item different is page 3, which shows the provider breakdown of the AEL allocation as we've used the factor data by county to determine the appropriate share of funding for each provider considering the counties that they serve. That concludes my remarks, and I'd be happy to answer any questions.
Any comments or questions?
No, Chairman.
None here.
Is there a motion?
I move that we approve program year 2020, fiscal year 2021, AEL block grant allocations, and the executive director is hereby ordered to administer these block grants allocations in the most feasible and economical manner and within all guidelines prescribed by HB 1, General Appropriations Act, 86 Legislature, regular session, the Texas Labor Code, and the TWC rules.
Second.
Thank you.
Been moved and seconded.
Yes.
Motion carries. This is item 9. Item 9, Chapter 800 rules on contracts purchasing is being postponed to a future meeting. Okay, that would bring us to item 10. Discussion, consideration, and possible action regarding proposed rule reviews under Texas Government Code, Section 201039 relating to jobs and education for Texans grant program, vocational rehabilitation services, career schools and colleges, administrative rules and regulations, business enterprises of Texas, VR services, and VR services contract management requirements.
Good morning, Chairman, Commissioners, Mr. Cerna. For the record, this is Joel Mullins with Workforce Development. Texas Government Code Section 2001.039 requires that state agencies review their rules every 4 years to assess whether the reasons for adopting or readopting the rules continue to exist. Additionally, the assessment includes the determination of whether the rules are obsolete, whether they reflect current legal and policy considerations, and whether they reflect the Commission's current procedures. In accordance with the rule review requirements, staff is seeking direction on publishing a notice in the Texas Register notifying the public of our intent to review Chapter 804, Jobs and Education for Texans Grant, Chapter 807, Career Schools and Colleges, Chapter 850, Vocational Rehabilitation Services Administrative Rules and Regulations, Chapter 854, Business Enterprises of Texas, Chapter 856, VR Services, and Chapter 858, VR Services Contract Management Requirements. After a 30-day public comment period, staff will bring forward the results of the assessment. I'm happy to answer any questions you have.
Comments or questions?
No comments here, Chairman.
None here.
Is there a motion?
I move that we file a notice of intent for rule review with the Texas Register for chapters 804, 807, 850, 854, 856, and 858 as recommended by staff.
Second.
Been moved, seconded, motion carries.
Thank you.
Item 11, discussion, consideration, and possible action regarding proposed rules pertaining to the Agricultural Improvement Act of 2018. The SNAP EMT good cause process is being postponed to a future commission meeting. This will bring us to item 12. Discussion, consideration, and possible action regarding statewide initiatives funded with Workforce Innovation and Opportunity Act, temporary assistance for needy families, adult education, literacy, child care, and other state level funds.
Good morning, Chair, Commissioners, and Mr. Cerna. For the record, Jen Troke, Workforce Division. Over the past year, the Texas Workforce Commission, in partnership with the Office of the Governor, Texas Workforce Investment Counselor, QUIC, and Rural Capital Area Workforce Board have worked together to develop a new evidence framework to better measure the impact of publicly funded workforce development programs. A goal of the work is to discover innovative approaches and replicable models that lead to transformative outcomes for workers and employers. This approach creates an evaluation point structure that incentivizes grant applicants to identify and use program models that have demonstrated a record of effective outcomes. In August 2019, the Commission approved $1.8 million in WIOA statewide funding for the Building Construction Trades Request for Applications, or RFA. The team is preparing to implement the evidence framework into this RFA, which includes incorporated evidence tiers and needs-based metrics. Recognizing that many Texas youth ages 16 to 24 are not currently engaged in employment or the workforce, also known as opportunity youth, and the growing demand for workers in the construction trades, staff recommends prioritizing opportunity youth models in this RFA that provides training and demand skills that can be learned and applied quickly. Additionally, staff recommends that an evaluation of the project be conducted to ensure that we are learning from the youth training projects, figuring out what works, and providing real-time adjustments to programs so that training participants are positioned for long-term success. Today, staff are seeking Commission approval to prioritize opportunity youth as the eligible participants in the 2020 Building and Construction Trades RFA, and competitively procure a program evaluator who can support the implementation of these grantees using up to $300,000 of the $1.8 million in funding previously approved for this project. Any questions?
Comments or questions?
No questions, Chairman.
Chairman, one quick question. Jennifer, are program evaluators, are those common uses under grant programs or program evaluators? Or is this the first time that we're doing that?
It's the first time that TWC is doing that, but this is a practice that's been, I would say, advancing more and more in recent years. And so the idea is that by evaluating, we then know what works, and then we're putting our money in the future into those programs that are working. So it's a smarter way to invest.
Good. It tells the story. Good. Thank you.
Well, yeah, certainly.
Thank you.
Yeah, certainly. Commissioner Demerson, that is true, and just want to also point out that we're breaking a little new ground here in the way we'll be doing, or at least seeking applicants. You know, we're sort of broadening our pool of applicants here and giving ourselves more opportunities to succeed. In my opinion, I think that this evidence-based approach to selecting folks to do these workforce programs that we have is a little bit of a departure from some of the ways we've done it in the past. I think it gives us additional capabilities, and the evaluator, if I understand it correctly, gives us a chance to evaluate this new process. While it's at least new to us, it's not a new process in the broad scheme of things. But while we're mastering this progress, it gives us a chance to both update what we're doing and then update or keep the process kind of moving forward so that we can understand it better for the future.
Good. Applaud that. Good.
Yeah, for sure. Any other comments or questions? Do we have a motion on this?
Yes, Chairman. I move that we approve modification to the 2020 Building and Construction Trades RFA to prioritize opportunity youth as the eligible participants and competitively procure a program evaluator who can support the implementation of these grantees and work cooperatively to build the evidence base for youth workforce development programs using up to $300,000 of the $1.8 million in funding previously approved by this project, for this project.
A second.
Been moved second. We're unanimous. Thank you.
Thank you.
This will take us to agenda item 13. Discussion, consideration, possible action regarding guidance on resource utilization and implementation, services and strategies to target disaster relief efforts, public health emergencies, including those funded with the Department of Labor's Disaster Dislocated Worker Grant. Mr. Cerna.
Yes, sir. We have a couple of updates for you. First, Clay Cole has got 2 items, and I think Chris is actually going to present the first item, Chris Oakley. So go ahead.
Yes, sir. Good morning, Chairman, Commissioners, Mr. Cerna. For the record, Chris Oakley, UI Division. At the last open meeting on June 23rd, the UI Division was instructed to provide an update regarding the performance of UI policy during the COVID-19 pandemic. The following is our update. Each time the federal government has passed UI-related legislation or Governor Abbott has issued orders dealing with the COVID-19 pandemic, the UI Division believes the TWC has acted appropriately in passing on flexibilities to customers. In response to COVID-19, the TWC has waived the initial waiting week, waived work search, suspended offset overpayment recovery for regular unemployment, implemented emergency rulemaking to align with the new federal programs, issued suitable work guidance, and suspended and delayed chargeback and reimbursement recoveries. Additionally, within the UI Division, our policy department works on a daily basis with operations to ensure that we are serving our customers as efficiently as possible. However, each time the DOL has provided information and guidance, they have also stressed the importance of program integrity. The UI Division continues to follow DOL guidance and strives to administer these programs, along with state unemployment, in a proper and compliant manner. After conducting the review requested at the last commissioners' meeting, our opinion is that our existing laws, rules, and policies have performed well and provide the intended flexibilities to customers under current laws. We find no reason to alter or modify our current strategies and see no current opportunity for rulemaking under the current state and federal legislation that provides the flexibilities benefiting Texans during the COVID-19 pandemic. We also identified and reviewed the following areas. First is the safety requirements of those employers opening or operating their businesses during the COVID-19 pandemic. The UI Division notes that guidelines for opening and operating businesses during the pandemic can be found, among other places, in the Governor's Open Texas Rules, the Department of State Health Services, the Department of Homeland Security, and the Centers for Disease Control. Additionally, businesses have taken these guidelines and crafted their own specific guidelines that best cover their unique circumstances. The UI Division believes that continuing to utilize our existing laws, rules, and policies on a case-by-case basis works best to promote the opening of the Texas economy while safeguarding the safety of employees. Our opinion is that additional rulemaking in this area might operate to limit our adjudicator's ability to fairly determine whether the employer is safeguarding the prospective employee's health and safety at the workplace. Furthermore, the UI division believes it is not within the TWC's purview to decide which of the guidelines published by the various entities are best for Texas. We can only determine on a case-by-case basis if a particular employer is providing a safe working environment for a particular employee, not make an overall ruling on the applicability and sufficiency of the various guidelines for Texas. The second area is our administering of the PUA program. The UI division continues to administer this program in compliance with DOL guidance. As of Monday, June the 29th, approximately 699,000 claimants have filed for PUA, and of those, 420,000 are self-employed individuals, and as a result, do not have regular unemployment eligibility. As explained by the DOL, the program is often of short-term duration, and the numbers do not appear to be out of place. Also, when Texas triggered on to the extended benefits, we triggered due to the insured unemployment rate, not the total unemployment rate. This leads to our conclusion that regular benefits are being paid to the majority of claimants, and that the PUA program has been reserved as a program of last resort, just as it was intended and as it has been described by the DOL. However, we monitor DOL guidance on an ongoing basis. If at any time DOL issues guidance that in some way allows the expansion of the PUA program, we will not hesitate to implement that guidance. In conclusion, the UI division understands that numbers and data don't always give the true picture of crisis and of those that are suffering as a result of the COVID-19 pandemic. Every day, we receive calls from claimants that are suffering and in crisis as a result of this pandemic. And each one of those claimant stories moves us on a personal level and motivates us to do our jobs better. We constantly work to provide comfort and assistance to claimants in need, striving to make the customer experience the best possible. Our policies should provide clarity to the process, and we will continue to monitor them to ensure that they do just that. That concludes my report, and I'm happy to answer any questions.
Comments or questions?
Chairman, I do have comments at this time. First of all, I want to applaud and I want to thank Chris, Mr. Oakley, for the great report that you just brought forth and the research that you put together for today's meeting. I certainly appreciate it, and I think we all do. I would like to state, though, I would ask that the staff bring forth a policy concept for rules related to good cause for refusing suitable work based on the guidance adopted by the Commission on June 16, 2020 for COVID-19 impacted claimants. Maintaining ability and availability, eligibility when refusing work because of those factors, and work search exemptions for part-time employees whose hours were reduced by the employer because a business was impacted by COVID. I feel that it's important for us to keep in mind that this allows us for transparency, and I certainly would appreciate public input. There's a lot of confusion among UI claimants, in my opinion, and by what we've experienced here at the office. Clear rules will provide guidance. Those are my comments, Chairman.
First of all, let me thank Chris, Clay, and Lachey, and that entire UI team for partnering with us in the governor's office on these virtual town hall meetings that we've had over the past, bringing valuable information to the Texas Employers Associations. And so we appreciate the work you're doing. That report that you just brought is something that's of value, and that we appreciate the work that you guys are doing.
All right, any other comments or questions? All right, Mr. Cerna.
I think Clay's got a standing UI update.
All right.
Good morning, Chairman Daniel, Commissioner Demerson, Commissioner Alvarez, Mr. Cerna for the record. Clay Cole, Unemployment Insurance Division. We'll start off with our UI claims and payment activity update. Over the past 4 weeks of June compared with the last 4 weeks of May, claims are down slightly. However, we still have averaged approximately 146,000 claims per week in June. This includes all claim types. And to date, we've processed over 3.5 million claims and paid out over $15 billion in unemployment benefits. Now, the 3.5 million represents approximately 2.7 million unique claimants, and we have processed approximately 2.6 million claims. Next week, we anticipate an uptick in claims as it's a quarter change. And anytime we have a quarter change, we have new people eligible for regular benefits based on their wage credits. But you can see that comparison in the total number of unique claimants, 2.7, and the claims process, 2.6. Just want to commend all our UI staff, our contract call centers, and volunteers for their great work. And clearly, we understand we still have a lot of work in front of us, and we're continuing to strive to meet the needs of our fellow Texans. And efforts to improve our overall service delivery, we are continually working to expand skill sets of our contract call centers, constantly working with them on training, developing new assignment types that they can work. And this is just continuing to free up our staff in UI on more complex back-end assignments and outbound calls. UI is hiring an additional TWC temporary staff just for our overall support too. Just want to make sure y'all can hear me clearly. We continue to see improvement in our assignment management. Very pleased with the improvements we're seeing there. We've been able to successfully backdate claims for those that had difficulty getting through to us. And we still have some work there, but at this point, we're at a point where we can address backdated requests on a case-by-case basis as we go forward. Just want to thank IT and our UI staff. Over the weekend, we deployed the state extended benefits programming, which provides 13-week extension of unemployment benefits to individuals who have exhausted the pandemic emergency unemployment compensation and remain unemployed. The first payable week for the state extended benefits will be this weekend, July 4th. So those individuals that are exhausting the PEUC, the emergency unemployment, now will transition automatically over to the state extended benefits. Again, just want to thank those teams that were able to deploy that successfully over the weekend. Of course, as we deploy one program yesterday, we are officially notified by the Department of Labor that the Texas Workforce Commission is now triggered on to high unemployment period beginning July 5th, 2020, which extends potential duration for benefits for eligible claimants up to 7 weeks or 30% of their regular entitlement. This extension is for individuals that will exhaust state extended benefits. So those that will come on here July 5th, once they exhaust that, they're potentially eligible for an extension of 7 weeks because of the high unemployment period Texas is now triggered on. It also potentially adds 7 weeks to the pandemic unemployment assistant individuals. So it would take them from right now 39 weeks to 46 weeks potentially. And what we're looking at right now, the first payable week, say if somebody triggers on to the state extended benefits and gets 13 weeks. So the first week they would be eligible for the new high unemployment period would be the week ending October 3rd, 2020. So IT and UI will be working on implementing that new program. And finally, UI and IT are working on a portal for employers to report return to work date for employees that they're working to retain. The portal will capture return to work dates for employees on temporary layoff up to 12 weeks. And if it's beyond that, we'll need some justification and talk through some of that. But right now, initially, we tell them to give us that 12-week, and then we can talk later. These individuals with the return to work date will be exempted from work search as the company works to reopen. We plan to have this ready sometime next week, and we continue to work closely with external relations on messaging for all these things that I've discussed today. And this concludes my update, and I'll be happy to answer any questions you might have.
All right, any questions or comments?
Chairman, I just wanted to take this opportunity to thank Clay. Great report and great update. Thank you, Clay.
Thank you.
I likewise would like to thank Clay and the team. Clay, you mentioned messaging and the information that you just laid out. That's going to be very, very, very important. And so information on our website, information working with my team as it relates to employers, we want that information because we love to provide this valuable information in those dates. And the more we're proactive with it, the less the amount of questions we'll receive in regards to it. And so this is new, again, for a lot of people, a lot of companies, a lot of individuals. And so the more we're messaging and getting that word out. It's very, very, very important. I want to communicate the need to do that.
I hear you loud and clear. I agree.
Thank you.
Thank you, Clay.
Thank you.
One last thing, Mr. Chairman, under this agenda item, of course, we agree with Commissioner Demerson and all of y'all about the importance of messaging. With regard to that, based on the increase in COVID-19 cases and the governor's June 26 executive order, we'll be pausing the reinstatement of the work search requirement for unemployment insurance. We'll continue to monitor the situation and come back to the commission in late July with a recommendation regarding reinstatement. But at the current time, we're going to pause the reinstatement. I'll answer any questions y'all have.
Yeah, I think given everything that's going on, that's a very prudent move. My opinion is we should pause that and reevaluate the situation. We're seeing continued claim activity in numbers that would suggest there's still more to come. At least that's what I'm sort of processing through after hearing Clay's report. Certainly, we've seen a pause on some reopenings. A lot of our discussion a couple weeks ago when we talked about this last time was related to reopening. With that paused, I think for us to hit the pause button here now is a very prudent move and one that I could support. Commissioner Alvarez?
No, I agree with you, Chairman. Ed, thank you for the update. And again, thank you for allowing the commissioners to have input in this decision. I think it's really important that we continue the dialogue with you. And I, again, appreciate your remarks and you working closely with the three commissioners or the commission during this time. So thank you for that, Ed.
Yes, sir.
I just add, Chairman, something you mentioned early on, being flexible, nimble, and taking care of business, proactive is the way that we want to go. And so keeping in lockstep with reality and what's happening out there keeps us relevant. And so pausing at this point makes a lot of sense.
All right. Mr. Cerna, that's an operational issue and one that falls in your jurisdiction. I do appreciate the update, and I do think that moving through July is a prudent pause.
Thank you, sir. That's all we have for this agenda item. I think
Right.
Tom has an update.
Great.
That doesn't look like Tom.
Good morning, Chairman Daniel, Commissioner Alvarez, Commissioner Demerson, and Mr. Cerna. For the record, I am Michael Britt, Director of Governmental Relations in place of Tom this morning. We will be monitoring one congressional hearing this week. This morning, the U.S. Senate Health, Education, Labor, and Pensions Committee is holding a hearing right now to receive a COVID-19 update on progress towards safely getting back to work and getting back to school. We also continue to monitor congressional action on potential legislation that would provide further assistance to those affected by COVID-19. And we'll keep you updated if there's any developments there. And I'm happy to answer any questions that you all may have.
Any questions?
No, Chairman.
None here.
I wrote all my questions for Tom, so I don't have it for Michael. Thank you, Michael. Mr. Cerna.
I have one thing under the Executive Director's report, and that is a bit of good news. eRepublic, Government Technology Magazine, has recognized our Work in Texas website with a Best in Texas award. We were recently awarded that. So, though we know we still need to continue to work on it and improve it, even though it's new, we did receive that award. So,
Well, I'll take some good news.
That's really good to hear. Really good. Thanks, Ed, for that.
Absolutely.
Chairman, you see my hands up over there? I'm using technology there. You see that thumbs up over there?
Yeah, that's right. That's what I like.
Learning
Anything
this.
else that needs to come before the commission? No? Is there a motion to adjourn?
Chairman, I move that we adjourn.
Second that motion.
It's been moved and seconded that we adjourn, and we are adjourned. Thank you all.
Thank you.
Yeah. Good job.